This is, as you know, one of our Northern Province lectures. I want to express gratitude to Lizzie Wilson and to her firm Wrigley's, who have been behind the series of Northern Province lectures that we have had. Originally, they were intended as a counterbalance to the perceived metropolitan bias within the Ecclesiastical Law Society. And one of the curious effects of the coronavirus is that, in fact, the lectures are now reaching a much wider audience than they would have done had they been merely hosted in the Northern Province. This evening, I am delighted to welcome Dr. Eve Poole to give the lecture. She is from a very distinguished background, both as a writer and in the public and private sector, including several years working with the church commissioners. The areas where she specializes are in leadership and in change management. But in 2018, Eve was appointed as third Church Estates Commissioner, and among the various responsibilities entrusted to her was one particular activity, that in effect being the midwifery of a new Cathedrals Measure, ensuring it survives through its passage in General Synod and comes in due course onto the statute books. I'm always slightly perturbed when I hear the term new measure, because it inevitably means a further edition of my textbook and all the work that involves. So doubtless this will be something to look forward to in the years ahead. Eve tells me that although she herself has no legal training, she has many family members who are involved in the law, both as academics and certainly north of the border at the bar and on the bench. So in many ways, the law flows through her veins. But without more ado, I'm going to hand the microphone over to Dr. Poole to give us a fascinating lecture on the changes that we can expect in relation to the governance of cathedrals. Eve, thank you.
Good evening. What unites the years of 1931, 1963, 1976 and 1999? Good vintages, perhaps? All these lucky years of the 20th century were blessed with a Cathedrals Measure, and at the moment we're in a fever of excitement in the hope that 2021 might one day join their ranks. Tonight I thought I'd share with you my experience of shepherding this one through the legislative process thus far, explaining the key changes being made, reflecting on this waypoint in the evolution of cathedral governance. But first, some context. In 2016, the episcopal visitations at Peterborough and Exeter had exposed some serious problems that raised important general questions about the structures by which cathedrals are governed. At the same time, the church commissioners had produced a report on the financial sustainability of the sector, showing that a large number of cathedrals were under significant financial pressure. These developments led to the establishment of the Cathedrals Working Group, which reported to Synod in June 2018. The key innovation of their report was the move to address an anomaly. While PCCs and DBFs, and indeed the Church Commissioners and the Archbishop's Council, are regulated as charities by the Charity Commission, cathedrals are not. As well as this proposed regulatory change, the report also sought to bring cathedrals in line with more traditional charity governance by assigning the trustee role wholly to the chapter and ensuring that a majority of trustees are non-executive. This was designed to underlie the demarcation between the oversight and governance of the cathedral and its day-to-day executive operation and management. The report also made recommendations aimed at strengthening cathedral disciplines concerning finance and safeguarding, and recommended that the incoming Third Church Estates Commissioner be given responsibility for the implementation of the report's proposals. So how does the incoming Third Church Estates Commissioner get up to speed on cathedral governance? Searching in vain for any mention of cathedrals in Hooker's Laws of Ecclesiastical Polity, I set off to Cambridge to find out, where I was advised to read the Rule of St. Benedict and Barchester Towers. Being somewhat allergic to Trollope, I fell back on that trusty Anglican manoeuvre, the St. George's House consultation, kindly financed by the church commissioners. Soon I was in Windsor, surrounded by deans and theologians and a brace of bishops to boot, with our own supreme governor in residence in the upper ward. Our task was to look at what theology might have to say about cathedral governance. By the way, it's an intriguing question for another day about why Hooker was so silent about cathedrals, given that his parents lived through the dissolution and he went to school in Exeter in the shadow of one. But perhaps as they were in those days so clearly run by the bishops, they fell into his episcopally led scheme and needed no other treatment. Anyway, we were agog and it was a very fruitful conversation. In preparation, I worked with the theologian Julie Gittos, herself a residentiary canon, to canvass the views of several eminent theologians. Our rather quirky two-part exam question was this: why would God not leave a dean to run a cathedral on their own? And who else would God involve? As well as 8 very different and intriguing answers to these questions, we also had submissions from 5 bishops on the proper relationship between a bishop and their cathedral, including an excellent essay from the Bishop of Exeter drawing on his Benedictine formation. Thus armed, we braved the Queen's Guards at the Henry VIII Gateway and sallied forth across the lower ward to Vicar's Hall. Our first day was spent considering ecclesiology with Paul Avis, formerly canon theologian at Exeter Cathedral, and exploring history and context with David Hoyle, then Dean of Bristol. The Bishop and the Dean of Derby then shared with us their way of navigating the Bishop-Dean relationship, and the following morning we eavesdropped on a fishbowl conversation between the theologians Julie Gittos, Paula Gooder, Jess Martin, Ben Quash, and Sam Wells, as they mused together on the essays we had pre-circulated and their own thoughts on theology and governance. I'll draw on some of their specific insights later, but you will by this stage be wondering how this April theological interlude shaped the draft measure that we brought back to Synod that July. Apart from generating the obligatory theological GS-MISC, it sharpened our thinking in a number of key areas. For instance, we spent some time considering the community-held flavour of a cathedral. It was suggested that while cathedrals were often described as independent, interdependent felt the better word, because all sorts of people feel a sense of ownership of their cathedral. Perhaps communities used to feel this about their parish church, and many still do, but the easy way in which people who might not broach a church door breeze into their cathedral suggests that any governance structure that is too churchy cannot represent them. This swiftly led us to agree that the proposed dual regulation by both the Church Commissioners and the Charity Commission was the perfect way to reflect this complexity. If cathedrals in so many ways embody the partnership between church and state, their oversight should too. This would also make it clear to secular funding bodies that cathedrals were not somehow above the regulatory regime of their other grant recipients and were entirely open to public scrutiny. And because the public have a genuine stake, they should quite reasonably expect cathedrals to exemplify excellence in secular best practice, just as they embody excellence in church practices of various kinds, be it music, liturgy, architecture, or anything else. The discussion on regulation shaded into a discussion about accountability, when it also became clear that a body like the Cathedral Council could indeed be a vital mechanism to bring together these various stakeholders to support the cathedral chapter in its more formal governance role. In this, we surprised ourselves, the report itself having taken a rather dim view of the efficacy. But our newfound enthusiasm for councils was nuanced. Our conversation included a debate about the impossibility of even the best governance structure being able to work in a context where relationships are broken down. It is too easy to slap law onto recalcitrants, but we felt covenant is better than contract because everyone needs to work at it. And just having one advisory council might not be right either, if the mission of a particular cathedral suggested other such councils, for instance, to advise on youth work or reconciliation or anything else. So making these non-statutory would give them vital freedom to negotiate a particular relationship with the cathedral in its locality, with its particular set of gifts and opportunities. Theology helped us too with the idea of inspection. If cathedrals aim to be truly excellent, why would they want to wait for the 5 years recommended by the report to learn how to improve? And why would they not want the whole of their life to be scrutinised, not just the financial bits? There was therefore strong support for the more frequent, comprehensive and ongoing inspections that are already being piloted through the new cathedral peer review system. With the right processes and training, these could become the vehicle for supporting and embedding the best practice guidance that will underpin the new Cathedrals Measure, as well as providing a catalyst to speed up learning between cathedrals and to develop a culture of continuous improvement. In our musings, we ranged far and wide, identifying recommendations both great and small. One was that all new bishops should be required to serve in residence in their cathedral for at least a week as part of their induction, so they can experience at first hand the rhythm of life there, given that the cathedral is the seat of the bishop. Another was a reflection on St. Paul and the reminder that administration is one of the gifts of the Spirit. We thought that in spite of the report, we ought to baptize this word rather than consign it to history in order to recognize the vocational nature of this gifting. This is the thinking behind the specific wording in the new measure, which states that the Constitution must provide for the appointment of persons to undertake administration in the cathedral through the carrying out of the role of a chief operating officer and the role of a chief finance officer. It was these several insights that informed our emerging approach to the draft measure itself. It confirmed in our minds that too rigid a legislative frame would do violence to the variegated local conditions of each cathedral and its ecosystem, and that the measure should seek to be enabling rather than prescriptive in tone. This argued for a light legislative carapace, supported by a denser web of guidance and regulation, which could more easily be customised and updated over time. Our conversations on oversight and regulation clarified the need for a memorandum of understanding to govern the relationship between the Church Commissioners and the Charity Commission, who would sign off on a standard form of words for cathedral constitutions, leaving each cathedral to set out its particular arrangement in details in its statutes. This was the process that had already been used successfully for registering the Welsh cathedrals, and would also allow us to work in partnership to ready the cathedrals for registration. We have since agreed to adjust the deadline for registration to take account of the COVID-19 pandemic, and are now proposing a long stop date of 3 years after the measure receives royal assent. I should say that in this process, I have been delighted by General Synod. One hears dark tales about acrimonious revision committees that end in stalemate. We had a brilliant steering committee and an expert revision committee, some of whom are on this call today, who worked incredibly hard on marshalling the many amendments we received and coming up with elegant solutions for their accommodation. I was very proud to be part of such a robust and productive legislative process. It's always interesting to see what provokes the most debate during legislative processes. And today I've singled out 5 areas which drew our particular attention to tell you about in more detail. The first is safeguarding. Because it is the trustee body in any charity which holds the core responsibility for safeguarding, as part of this process, we have decided to amend the Safeguarding and Clergy Discipline Measure 2016 to include the chapter of a cathedral on the list of those required to have due regard to the House of Bishops' guidance on safeguarding. One serious gap in the 1999 measure was the absence of any specific mention of safeguarding. We were at pains to ensure it was clear on the face of this cathedral's measure that it should be a specific duty of the dean. So we inserted a new clause to say that the dean must provide leadership on matters relating to the safeguarding of any children or vulnerable adults who work, volunteer, or worship in the cathedral or who visit the cathedral. While the guidance on safeguarding across the Church of England has been constantly refreshed, we've been grateful to be able to draw on the learning from the independent safeguarding audits being carried out on the cathedrals by the Social Care Institute for Excellence. We're about halfway through them now. After the pilots of Carlisle, York and Canterbury in 2018, there were a further 16 audits carried out in 2019 and 4 prior to lockdown this year. Another topic concerned the cathedral's relationship with their diocesan bishop. Because the 1999 measure had enabled the bishop to attend all council meetings, there was an expectation they would also regularly attend chapter. However, both bishops and the deans pointed out that this would compromise the bishop's independence should they ever need to hold a visitation, because through attendance they would have become complicit in chapter's decision-making. Instead, we invented a new device to enable both parties to meet in their own right. Section 11.2 of the draft measure therefore states that the chapter must each year hold a special meeting at which A, the chapter must consult the bishop on the general direction and mission of the cathedral, and B, the bishop may, in reliance on section 9.5, seek the advice on the chapter on any particular matter. Now, there were a couple of naughty deans who referred to this as the annual Christmas drinks, but we very much hope it will, in fact, become a new and productive feature in the cathedral calendar. Another area was about lay people carrying out ecclesiastical roles, and arose from confusion, both about the role of the vice chair and about the potential removal or disqualification of trustees by the Charity Commission. Early reaction to the cathedral's working group report had surfaced a concern that the proposed lay chair, or bishop's narc as it came to be termed, might run the cathedral in the absence of the dean. And this concern quickly translated into one that went straight to the heart of the jurisdictional boundary between secular and ecclesiastical law. If cathedrals are regulated by a secular authority like the Charity Commission, could they use their powers in extremis to appoint a secular person to run the cathedral altogether? We resolved this in two ways. First, we made it clear that if the dean was out of action, the sub-dean or an acting dean would immediately be substituted to attend to the normal running of the cathedral. The substitute would chair chapter as for the dean. But given that the dean, when chairing chapter, is there in trustee mode, should the absence just be a temporary one for that meeting, it would make sense for the next most senior trustee to run the meeting, i.e. the lay vice chair. We renamed this person the senior non-executive member to make this point clear. We also made it clear that should a dean or residentiary canon be removed as a trustee by the Charity Commission because of egregious behaviour, the bishop would activate the parallel process in ecclesiastical law to remove them from their office. In reaching this conclusion, we were helped by a quite magnificent piece of staff work, parsing the various causes of recent disqualifications by the Charity Commission, which showed that these powers were never used lightly. There are in the region of 168,000 charities registered with the Charity Commission and some 700,000 charity trustees who hold some 943,000 trustee roles. During the financial year 2017-18, the Charity Commission only disqualified 14 people from acting as charity trustees. And during statutory inquiries, the Charity Commission only suspended 10 trustees or officers and only removed 10 trustees or officers. Those disqualified had variously been discovered at Heathrow with suitcases full of cash, had used charitable funds to finance exotic holidays, and had invented beneficiaries in order to raise funds for their own use. It was clear that mere Barchester-style toadying for preferment by marrying well would therefore be insufficient grounds. At one stage in the process, we found ourselves having a rather Alice in Wonderland conversation with staff at the Charity Commission about how on earth one would set about closing a cathedral should the charity ever fail. The answer to that question serves to illustrate the peculiar position of the Church in the complex legal, political, and social life of the nation. First, you can only close a cathedral if you designate another church the cathedral instead, as they did recently in Aberdeen in the Scottish Episcopal Church. Either that, or you have to surrender the bishopric, which the excellent Becky Clark reminded me last happened in 1550, when Westminster Abbey surrendered to London after being a cathedral for only 10 years. I gather this law is still on the statute books, but I'd need your learned help to track it down. I note that even though the creation of the Diocese of Leeds reduced the number of dioceses in the area, their 3 cathedrals survived the merger. But imagine that you did decide to get rid of one of the cathedrals, St. Paul's, say. You might give the job of cathedraling back to Westminster Abbey. Then what? In demoting St. Paul's, you would need to ensure it retained residual status as a church of some kind in order for the Mission and Pastoral Measure 2011 to kick in, to avoid it being in jurisdictional limbo. The bishop would then have to ask the church commissioners to publish a scheme for closure, which involves extensive consultation and gives citizens and various statutory bodies the right to make representations. Perhaps a good case could be made for the otherwise comparatively luxurious provision for the cure of souls in the City of London, but to what alternative use might Wren's masterpiece be put? The uncertainty about the future of one of Britain's most iconic buildings might well attract adverse representations, necessitating a public hearing and the possibility of an appeal to the Privy Council. Should these barriers be surmountable, the quest for a suitable alternative use would need to be undertaken in the diocese by the area council with oversight of the deanery of the City of London. Elaborate adverts would no doubt appear in Country Life and The Week and on Rightmove and Zoopla, but any purchaser would need to be able to demonstrate they had the 10 million a year required for upkeep, as well as the wherewithal to absorb any unexpected repair bills. In order to finance these running costs, the building would need to pay, but its high listing would prevent any conversion to office or residential use. It's true that St. Paul's has space in its dome to best St. Paul's Bristol, a CCT circus church, which hosts the only, so far, full-size flying trapeze in the UK. And the bigger churches certainly make good climbing centres. But even so, I fear it'd be very hard for such uses to gain listed building consent for list entry number 1079157, a Grade 1 building of exceptional interest, first listed when they invented such things on the 4th of January 1950 in pursuance of the Town and Country Planning Acts of 1944 and 1947. But enough of this flight of fancy. Suffice it to say that what was eventually agreed on the matter of closing cathedrals was that while the law would allow the winding up of the charity known, say, as Barchester Cathedral, it would otherwise continue as an ecclesiastical entity, administered in extremis by the Barchester Diocesan Board of Finance. Next, I was going to spend some time taking you through the very complex negotiations we had about cathedral year ends. Did you know that most cathedrals have a December year end? Apart from 10 that have a March year end, except St. Albans, which has a November year end. It would be neat if they all agreed, but it's not something that the Charity Commission insists on. So we handled that through an enabling clause, should we wish to tidy that up in the future. I also wondered whether I should tell you about our grandfathering clause for existing administrators, or the way we solved the parish church cathedrals anomaly through an enabling clause, or maybe you'd like more on how we came to agree that even unpaid executives were still executives because it was about function and not remuneration. But I think what you've all really been waiting for is news about what we decided on endowments. For many cathedrals, their property is so ancient that there is no paper trail about either provenance or the intent of any historical gift, which means that by default, anything ambiguous has to be deemed permanent endowment just to be on the safe side. This restricts how the chapter might treat such property, which cannot then be regarded as an investment for the purposes of portfolio management. So at section 23 in the measure, we give the church commissioners the power to rule on this, as they currently do on glebe. We also widen the commissioners' funding powers so that in future, as well as funding individual cathedrals, they might also fund bodies acting for cathedrals, such as CAFA and the AEC. In drawing together this survey of hot topics, it's important not to overlook the general effect of the central shift from internal regulation to co-regulation with the Charity Commission. As section 8.4 of the draft measure states, in the future, the members of the chapter of each cathedral have the general control and management of the administration of the chapter and are, accordingly, the charity trustees of the chapter for the purposes of the Charity Act 2011. While this is not the only or most important innovation in the measure, it is the most culturally significant. For the first time, cathedrals will be formally accountable to the state regulator, as it is expressed in the heads of terms that we've agreed with the Charity Commission for our Memorandum of Understanding. In the future, it will be the case that the Charity Commission and the Church Commissioners have a mutual interest in increasing public trust and confidence in cathedrals as charities. So we will be in a new partnership. And because we want cathedrals to be exemplars of best practice in this, as they are in worship and liturgy, we have also been at pains to bake into this measure the need for the chapter to keep its role as a learning organisation continually in view. Accordingly, we have given the new nominations committee a formal duty to advise on the training needs of members of the chapter and to keep under review the skills, knowledge and experience of, and the diversity among, members of the chapter, and to make recommendations to the chapter on how to make improvements. We have been grateful to the church commissioners for making available the funding to support this through training, as well as by providing legal support for the registration process. In closing, I'd like to return to an interesting thread of conversation that emerged during our deliberations at Windsor. It concerned the fundamental nature of governance itself, which Professor Ben Quash described as care. He suggested that an audit of what people cared about in any structure would be a very valuable way to discern the required governance of it. This would involve taking people's immediate responsibilities for things like worship, jobs, safeguarding and the environment, and aligning them with the cathedral's larger corporate responsibilities, because taken as a whole, cathedrals are really instruments of care for the wider world. This would suggest an organising scheme focused on care, with roles assigned accordingly, integrated through this single, uniting task. It would include identifying the best ways both to create and to relate to wider networks of flourishing in the wider world. To Quash's mind, when the word governance is used unthinkingly, it can be misheard as shorthand for management or control or processes, depending on the experience of the audience. Of course, governance includes all of these things, but the motivation underlying them all is care. Governance is therefore properly understood as attending to and auditing the things that we care about in a cathedral, like the people, the finances, and the fabric. Thinking of governance in this way positions it more in terms of an ecology, which maps back well to the idea of interdependence in cathedrals with their multiple stakeholder groups. Quash argued that seeing governance just as the imposition of a duplicatory oversight structure erodes trust and risks alienating and undermining the very people on whose emotional commitment the institution relies for its flourishing. Trust is crucial to foster an environment in which individuals feel safe both to admit to and learn from mistakes, and to see risk management as a conduit of grace. But trust cannot be assumed, it must be earned. Cathedrals are places of aspiration, and they hold in trust the gifts of numerous others who wish to participate in the holy. So what governance system could best encourage this? It was quite a challenge engaging with this narrative of care. Current cathedral governance has emerged over many centuries and through several modern iterations, as we've seen. It's resulted in a hybrid oversight model that is an accident of history rather than design, no matter how hard we are working to continually improve it. It made me yearn for a clean sheet. What would a governance regime look like if we designed for care? And to willfully misconstrue some Latin, quis custodiet ipsos custodes? Who cares for the carers? Well, it occurs to me that we've been churning out new Cathedrals measures on average every 20 years since the Cathedrals Measure of 1931. This makes the next one due around about 2041. If it did draw on a theology of care, what might it emphasise? I think it would be at pains to preserve the Holy Trinity of Dean, Bishop, Senior Non-Executive Member as the primary supervisory mechanism for watching the watchman, where all three could find challenge and support. I suspect under the current new measure, this largely informal mechanism will emerge as a real powerhouse for those cathedrals trailblazing this cultural change. And perhaps as well as the trustee body literally holding the central trust, we will see the emergence of a plethora of advisory bodies as expressions of care in all cathedral areas of both churchly and worldly activity. In the years to come, I imagine these tentacles like tree roots will have spread far and wide, such that these outposts, as they become established, may need representation on chapter in the future in a more formal way, akin to the portfolio structure of other board models. In the secular world, boards are focused on delivery, with non-executives there largely to mark the executive's homework and to keep them honest. Charity boards have traditionally been wholly non-executive to protect the very being of the institution for generations to come. The new cathedral chapter will be a mixture of the two, so it has the potential to demonstrate a healthy middle way. Perhaps the development of a theology of care might be exactly what the world of governance needs for its future rejuvenation across the sectors, with cathedrals leading the way. Finally, I'd like to pay tribute to my fabulous legal advisor, Eve Poole, and to Chris Packer for his exquisite drafting of the measure. The legislative process has been very much a community effort, steered by Robert Hammond as chair, with the Dean of Southwark's revision committee engaging with a wide range of stakeholders in order to agree a very much better draft than we could have devised on our own. We have been very fortunate with our contacts in the Charity Commission, who have been incredibly helpful in the process, and to members of the Ecclesiastical Committee, on whose advice we have also drawn. And I would like to pay tribute to you, the Ecclesiastical Law Society. We make the laws and you interpret them for your clients. And I hope you will feel as I do, that this measure will be a good addition to the statute books. And I thank you all in advance for helping us put it to work. Thank you.
Well, thank you, Eve, on all of our behalves for what was a marvellous overview of the measure, not just dealing with the practical details, but also describing so fully your thinking, your collective thinking on the purpose that lies behind it, and the theology and the doctrine and the ecclesiology, all of which needs to find some form of articulation within secular legislation. Now, it's abundantly plain that I wasn't the only one who was enthralled and enraptured by your presentation, because unless I'm misreading it, there wasn't a single comment in the chat room during the time that you were speaking, because people were hanging on your every word. But you've generously given time for us to ask questions and to push back on some of the observations that you've made. Now, Ian Blaney, I've spotted. If you'd like to comment next, and then when we've dealt with you, I'll take Neil Patterson, and then other people can join what I hope will be a modest queue to hear from Eve. So Ian Blaney first.
Thank you for the clarity of your presentation and the clarity of all the communications which have gone out from your group to those interested in the reform of cathedrals legislation. You mentioned that the cathedrals would be duly regulated by the Church Commissioners and the Charity Commission, the situation that you said was not unusual. For instance, schools and universities are also duly regulated, and there would be a memorandum of understanding between the Church Commissioners and the Charity Commission on aspects of working together. Of course, cathedrals will be, you could say, triply regulated in that diocesan bishops will also continue to exercise a right of visitation. And I just wondered whether any thought had gone into how to ensure that the episcopal visitation wouldn't clash with the regulatory role of the other regulators, and that role could be mutually complementary.
We've actually just refreshed our visitation guidance under the 99 measure because we were aware that those who had to conduct the visits at Exeter and Peterborough didn't actually have any formal guidance to help them. We're very alive to the fact that this could be an area where the tectonic plates of the different legal systems collide. So it's very much one of the areas we're going to explore in detail in the Memorandum of Understanding that we're agreeing with the Charity Commission. They, of course, are used to visitors in other environments, although with different legal powers, and they're used to co-regulation. And of course, the MOU is designed to try and iron out any potential areas of conflict or overlap so that it's very clear where one jurisdiction starts and where the other takes off. But if you want any further detail on that, do get in touch with me and I can give you some more information about it. Thanks for the question.
And I think I said I would take Neil Patterson next. So Neil will take your question and I'll look forward to welcoming others to question after you.
Thank you, Eve. Naturally, as a member of the revision committee, I basked in your kind words, but I wonder, with a different hat, which is as a member of a cathedral council, you could make some comment in a sense as what people should be doing by way of preparation, assuming that, I think as we all do, that the measure will pass in whatever form November synod happens. You know, we need to be ready to act, do we not?
Absolutely, and thanks for thinking ahead. Some councils are already updating existing constitution statutes, which they can do under their current powers to make ready. Winchester is doing that at the moment in order to replace Annabelle as administrator and trying to echo the new post that will be mentioned in the new measure. What we're doing with the Charity Commission at the moment is we are agreeing with them a sort of, if you like, a dummy registration process that we're going to take a few cathedrals through as a pilot group, so that what we can do is streamline the process and give very concrete advice to the cathedral community about what steps need to be taken. Of course, most of you already comply with things like the accounts, the model accounts that you already submit are based on the charity SORP in any case. So there are quite a lot of things you already have in place. It's mainly setting up the new chapter structure and new committees. So what we're doing is we're hard at work getting together all the guidance on that and working with the Charity Commission to make sure that whatever we agree in the Memorandum of Understanding is reflected in that guidance too. So we have recently recruited another person to Eva's team to help the cathedrals with this process, and we will be making sure you all get lots of help in figuring out when to start doing what. But thank you very much for the question and for being on the case about it.
Eve, while we're waiting for more questions, perhaps I could exercise my prerogative and ask about this. Has the effects of the COVID emergency given you cause to rethink any parts of the measure or the general direction of travel? Because good governance, professional administration comes at a very high cost. And I'm going to imagine there's a single cathedral in the land whose income hasn't been drastically affected by the closures up to now and likely closures in the future. Is this level of five-star governance still affordable?
It's a really good question. And I think we can't afford not to do it. These organisations are enormous and complex and need to be absolutely showcasing the very best of secular regulation as well as everything else they do so beautifully. What we have been doing, which we'd done even before COVID, was making sure we never do that thing which Synod can be quite naughty at, which is passing legislation that requires a lot of resource that isn't available. So the Church Commissioners had already earmarked £10 million as part of the Cathedral Sustainability Fund, which was designed to underpin all the changes that would be needed in order to get the Cathedrals Measure bedded in. And out of that would come the budgets I mentioned for training and also for legal help. What we have therefore been able to do with COVID is use the existing regime to get that money sent out to cathedrals in advance to safeguard the key posts that we would need in order to be able to keep delivering sustainable governance through this difficult period. What I would say is that I have been incredibly impressed with how robust current cathedral governance generally is, and that has been kicking in big time during this really difficult crisis, which has been a really good opportunity to see that the cathedrals already are observing an awful lot of best practice supported by the peer review process and everything else. And the Sustainability Fund is helping find and fund tactical posts to help with that. So I think it's just made us all feel that this is even more crucial. because many cathedrals said to us that the difficulty with trying to attract secular funding is trying to explain why you're not regulated by the secular regimes, as though the church is somehow special. And of course the church is special, but we haven't always covered ourselves in glory with self-regulation. And so as an act of very public trust building, submitting ourselves to the Charity Commission and embracing that is a really important cultural change. So I think that will only make us more robust and also make us more compelling as places that deserve state and secular funding as well as church support.
Thank you very much for the fullness of that answer and the thoughtfulness of it as well. I note that Anthony Archer has raised a hand, and if we can go to Anthony next, he can put his question to you, and we'll see if other people put their hands up while he's speaking or you're answering. Anthony.
Eve, thanks so much for your talk. A brilliant sweep through some great thinking and theological reflection leading to this measure. I'm wondering what thought, what's been given or needs to be given to, in the sense, developing a talent pool for suitably qualified people to really fit into this new governance structure. I'm a sort of headhunter by trade, or at least I was. And you've got, I agree with it, quite a tight framework in terms of the structure around the dean and chapter. For instance, the finance person needs to have a recent and relevant financial experience. That's really a sort of FTSE 100 UK corporate governance term. These people don't grow on trees, and I don't really think you can just cherry pick, even if you can find them, the best people of the existing cathedral councils.
I think that's such a good observation, and I know it's something that was talked about quite a lot in the debates around the Cathedrals Working Group report. There are some cathedrals who are blessed with a huge wellspring of talent they can draw on, and some cathedrals who, because of their location or their size or historical situation, find it much harder to have a list of people waiting in the queue. We're concerned about that for a whole host of reasons, not least because of Black Lives Matter. And one of the things that we're doing in London with the Church Commissioners Trustee Body and the NCI Trustee Pool is trying to start, every time someone expresses an interest in any voluntary church role of this sort, capturing them. And we're going to hold a series of events to try and attract candidates who would be suitably qualified for any volunteer roles in the sector, really, to express an interest and join our gang so that we can offer appropriate training and support. And one thing that we're hoping to do through the peer review process and also through the expert panel is to try and focus down on any cathedrals that have already identified that they may struggle with that, so that we can get ahead. Right. And one of the reasons for this phased approach to the sign up is that it'll give cathedrals a choice about how quickly they want to move towards registration, and those that need a bit longer to build up the right teams, the right talent, the right processes, the right financial stability, given what's just happened, will have a bit longer and a bit more support.
Well, the question in the chat box is simply this. It's taking us in a fresh direction. How is the fabric of the cathedral to be kept in repair under the new measure? In other words, to what extent do these provisions impact on the current provisions dealing with the repair of the fabric?
Well, in terms of regulation, the Cathedrals Fabric Commission for England will continue as it does. As we're all incredibly aware, there hasn't really been state funding for cathedrals for some considerable time, and money for fabric has had to be applied for through things like the lottery, which is quite literally lottery, and not all cathedrals get it. So one of the things we've been really concerned about is how we can build a case to getting more stable funding for fabric in the future. We have been talking to the Treasury and to DCMS quite a lot about that, and we're hopeful that there'll be some announcements soon about emergency funding for very immediate fabric problems. But we're also at pains to try and figure out what a new deal with the state would look like. And I'm spending quite a lot of time talking with Becky Clark to DCMS about that, because I think the nation is very well aware that it's been free riding on an asset it doesn't contribute towards. I think the nation expects cathedrals to be available and open in times of crisis and need, but there hasn't been any contribution from the Exchequer except through the odd VAT rebate for far too long now. The other thing, as I mentioned, is that there has been a technical block to some secular funding because of the lack of a charity number. So even though the cathedrals are obviously registered as charities for VAT, they can't, in these desperately awful forms you have to comply with in order to get through grant application processes, they can't fill that in, and they will be able to now. So the Church Commission's existing powers allow us to fund people. We can fund stonemasons, which we've been doing, and lay clerks and things like that. So we can continue to fund people who work on fabric, but we haven't had the powers under the current measure to fund fabric itself. And we still won't precisely have that power under the new measure, but it would be something that we might be able to look into should the cathedrals get into a situation where we can't find funding from elsewhere. But one of the things we're determined to do with this new measure and this new cultural change is to work very closely with the state and also other charities to try and figure out what a new deal for funding cathedrals in perpetuity would look like.
A very positive note. I saw within a comment box, Julia Barker had made an observation. I don't know, Julia, whether you want to speak to your comment and take this conversation a little bit further. But if you can be found and brought into the conversation, you'd be very welcome.
My comment was in respect to Anthony Archer's question about finding people to support chapters with appropriate skill sets. Now, the CFCE already do something very similar to support chapters with their FACs when they come round in the quinquennium, and they have a sort of advertising and recruitment process that could be copied for cathedrals looking for new chapter members. So that might be something that could be sort of expanded in that area.
Thank you, that's brilliant. And we just need to join the dots across the whole community on this, because there are an awful lot of people who want to serve the church, and we just need to figure out how we find them and how we match them up with the bits of the church that need their help. So thank you.
Well, there's a further opportunity to put questions now if you wish to, or if you feel you're satiated with your discussions of cathedrals and their governance, we can draw matters to a close. But I would hate anyone to feel that they've not had the chance to push back and to inquire in what's been a fascinating presentation this evening.
Well, if I might, I would really like to thank you all very much, because I came into this very new, and as you'll have heard from my talk, it was quite a learning curve getting to know the cathedral community. And I've been really humbled and impressed by the generosity of so many people who are involved in cathedrals, offering their expertise, their support, their wisdom, and their challenge, because this is a much better measure than it would have been because of all the feedback that we had and all the conversations we've had to try and get this right. And many of you on this call have been a really core part of that. So I would like to thank you all very much.
Well, I think we would like to respond by thanking you not merely for the work you've done in producing the measure and steering it seemingly effortlessly through the choppy waters of General Synod, but for the time you've given this evening in explaining it so lucidly. This isn't goodbye, I fear, Eve, because it's more au revoir. You've generously agreed, in addition to this evening's Northern Province lecture, to deliver one of the London lectures next year on the 12th of May, broadly encompassing this same subject. But as I think you hinted at one or two points in your paper, this is a relatively fast moving situation. And by the time we come to May of next year, things may be different. And we look forward to hearing the ways in which this forward-looking measure has progressed. Our other hope, of course, is that by May of next year, we're allowed to meet collectively and in person, rather than through the ether virtually. And I hope that when we do meet, then we can raise a glass in thanks to you and have a rather more animated and personal conversation rather than the disembodied one that we've enjoyed this evening. So on behalf of the Ecclesiastical Law Society, on behalf of everyone who's been part of this conversation, very, very many thanks to you, Eve. We're very much in your debt.
Thank you.